served on the NCCA for 6 years. I was elected to the board of directors of the Commission on Accreditation of Allied Health Education Programs, also known as CAHEP, in 2018, and I'm currently serving as president of CAHEP. My areas of interest are professional regulation and credentialing, ADA testing accommodations for schools as well as testing bodies, and general antitrust issues that impact credentialing bodies and schools. This case really grabbed my interest early on because of all of the misinformation that was being circulated. As I mentioned at the breakout session a few minutes ago, headlines were popping up such as, quote, online room scans for tests are unconstitutional. Now, what is the reader going to think, the average reader going to think when reading something like that? So I'm happy to be presenting with Rachel and Mark, and I think I'll turn it over to Mark at this point.
Thanks, Don and Rachel, and thanks to the CNG group for having us today. My name is Mark Weinstein. I've been practicing law for 25 years. 14 of those 25 years, the most recent 14, have been fairly focused on representing those in the testing industry, particularly sponsors of secure tests. And I also serve as an executive at Cavion Test Security. This case is of great interest to me and has been since the opinion was published for some of the reasons that Don mentioned. But also I started my career as a criminal prosecutor in Miami-Dade County, Florida. And so I have sort of a deep experience with the Fourth Amendment. And this case definitely was a head scratcher. And it prompted me to write an article on LinkedIn, which I hope you'll have an opportunity to read if you haven't seen it already, where I provide my analysis of the case and identify the reasons I think it's pretty strange. And I think we're going to get into that today. So I'm going to turn it back to you, Rach.
Thanks, Mark. Hi, everyone. Rachel Watkins-Shadig. I am also an attorney by trade, so you get three of us. We promise to make this fun and interesting, though. I have been protecting clients' intellectual property rights for decades now. And I started in the tire industry in-house from my in-house career, and then was recruited to come to ACT. So I've spent a lot of time in-house at testing programs, thinking about things like exam security and test taker rights and how to provide accessible and secure and fair exams. Today, I am CEO of Cornerstone Strategies, and our firm provides privacy, exam security, and executive services to the testing industry. One of our clients, in fact, that I provide executive services to is Examity, who is a leading online proctoring provider, and I serve as their chief science officer. So I have spent a lot of time thinking about this case, as I know Mark and Don have as well, and thinking about the issues that this case poses for testing programs, as well as vendors and providers of proctoring services. So before we get into the case a little bit more, first I have to give you our legal disclaimer, because we are attorneys, and what would this presentation be without some legal disclaimers? So we are not giving you legal advice today. There's nothing that we're doing today that is intended to establish an attorney-client relationship between us. The views that you are going to hear are those personal views that each of us hold. They're not necessarily the views of our respective organizations. We do want to hear from all of you today, so we would ask you to keep your cell phone handy. And also, we will be trying to capture or watch chat as we go through here, so feel free to plunk some questions in there if you have them as they come up. So the case we're going to be talking about, as Don said, has had quite a bit of media attention. It's called Ogletree versus Cleveland State University. It was decided by a federal court in Ohio, and that court concluded that Ohio or Cleveland State University had conducted an unreasonable search under the Fourth Amendment when it required the plaintiff, Mr. Ogletree, to conduct a room scan before one of his chemistry tests. A lot of the information, as Don has said, that was written about this, especially early on, was perhaps broader than any of us would agree that the case actually held. So what we wanted to do for you today is a couple of things. We want to break down this case further so that we can talk about what are some of the implications of the holding, what does it mean for testing programs and credentialing bodies, not just state universities. And also talk to you a little bit about, there's a process here that I think we, just from a legal perspective, folks should be aware of, because it's a little bit like a soap opera, and the soap opera has not concluded yet. So as I mentioned, we do want to make this interactive. So we would ask you to please grab your cell phones. And if you could turn your camera on, just point it to the QR code up there, click on that, and it will take you to a Slido poll. You can also just join at slido.com. But we wanted just to kind of get a sense from you guys, what do you think this court held? Again, there's been a lot of different communications on this. So did the court hold that room scans are illegal and should not be used for remote proctored exams? Did the court hold that room scans are unconstitutional as to Mr. Ogletree and the unique facts of that case? Did they hold that room scans cannot be used in university or college exams? Or did they hold all of the above? So we know there's several of you out there. We're going to give you a little bit of time to go ahead and register what you are aware of, the court holding in this case, so that we can kind of get a sense from you where you think this case is situated. So I think we've heard from about half of the folks, and I'll go ahead and share. We have about 15% of us saying all of the above, 10% saying that room scans can't be used in universities or colleges, about 15% saying that they're illegal and just shouldn't be used for remote proctored exams, and about 60% saying they're unconstitutional as to the plaintiff, Mr. Ogletree, under the unique facts of that case. So we will spend the rest of this time digging into this and circle back to that question here at the end. I want to start off with a question actually to Don, because as odd as it might sound, where this case was decided actually makes a really big difference. There's obviously a difference between a holding that comes from the United States Supreme Court versus a holding that comes from a district court in Ohio. And in the law, we tend to talk about things like the precedential value of a ruling and whether something is persuasive or controlling authority. So I wanted just to ask Don to take a few minutes to explain what that means.
Thank you, Rachel. Probably the best way to understand these two categories, control authority and persuasive authority, is by putting them in the context of precedent. Controlling authority can be seen as synonymous with binding precedent. In other words, if a superior court renders a decision on an issue, then all of the courts inferior to that court are obligated to abide by it. We know the Supreme Court of the United States is the ultimate legal authority, and all of the federal appellate courts or circuit courts of appeals throughout the country do have to abide by decisions that are made by the Supreme Court. Now, on the other hand, persuasive authority, this other category, could best be understood as precedent that is non-binding. In other words, if a case has been with similar legal issues and facts has been decided by a superior court, or rather a court of equal standing to the court that is hearing a matter, then it is good for the court that's hearing the current case to look at what that previous court said. However, this court in the new case is not bound to abide by that precedent. It's helpful. No doubt it will influence the court in gaining some information and sharpening its legal analysis, but it is not binding precedent. It is non-binding precedent. And that's what we have in this case. In doing a little bit of research on this issue, I also found that actually federal district courts or the trial courts on the federal level In other words, the first court on the federal level that would hear a matter is not even bound to abide by decisions in its own level in that district in making a decision. Certainly, again, the decisions of another court discussing the same issue are helpful, but again, they are not binding. Even in this Northern District of Ohio Eastern Division, another judge could hear another case and could come to a different conclusion. So it's important that we understand the limitation of this persuasive authority, which is not controlling authority. All right.
Definitely not the law of the land, right?
Correct. Yes.
Okay, so we have this case that's not a controlling decision, but it would be something that other courts would read. They may find it persuasive precedent. We don't really have anything like this out there. One of the things that makes this so unique is that the plaintiff in this case argued what is a somewhat novel argument here around the Fourth Amendment, which provides to individuals the right to be free from unreasonable government searches and seizures. And Mark, you told us at the beginning that you were a former prosecutor, which makes it really exciting to kick this over to you, because I know that this is something that you've run into, but in a completely different context in your career.
Thanks, Rach. Yeah, that's right. The Fourth Amendment, just to be clear, is the Fourth Amendment of the Bill of Rights to the United States Constitution. And basically what it says is citizens have a right to be free from unreasonable searches and seizures. And in the criminal arena, what that means is, for example, if the police sees evidence in violation of a person's Fourth Amendment rights, I mean, you can think about it in the context of a simple drug possession case. You know, they just see a person lawfully walking down the sidewalk, doing nothing wrong, not appearing to be doing anything wrong. The police stop the person, reach into the person's pants and pull out a bag of cocaine, which last time I checked is still illegal in all states, right? So then that person gets charged with possession of cocaine as a criminal violation. That person, through their lawyer, would file what's called a motion to suppress because of a violation of their Fourth Amendment rights. And most courts would probably grant that motion. So what happens as a result of the court granting a motion to suppress evidence? The evidence goes away, and then the judge looks at the prosecutor and says, do you have any other evidence? And usually the prosecutor says, no. That's the end of the case. So the remedy in criminal cases for a violation of a Fourth Amendment right is the suppression of evidence. So in other words, you can't use the evidence against that person who is charged with the crime. That is a typical application of the Fourth Amendment. This is not a typical application of the Fourth Amendment. Here, there was a room scan. So nothing was actually seized, right? So we're going to put that to the side. So we're really strictly talking about a search. But, you know, was it really a search? This was a scan of the room to see if the test taker was complying with all the testing rules before they took a chemistry exam in college. And the court said, this is a search. This is very unusual. In a civil context, meaning in a non-criminal context, the court, you know, encounters Fourth Amendment issues when there are significant safety or health concerns that the state has. For example, OSHA, the federal agency, can conduct searches of workplaces to ensure that they meet safety requirements. There are other instances, you know, for example, the EPA and state environmental regulators can conduct searches of power plants or other facilities that could produce pollutants that create unsafe hazards. So the Fourth Amendment applies to those searches, and the courts give, you know, regulators for safety and health a lot of leeway to go in and search at any time to look for those types of violations. One other example would be in a child welfare case. For example, a State Department of Children and Families could at any time decide to conduct an inspection or search of a home where a foster child has been placed and in other similar circumstances. So in those instances, the Fourth Amendment applies, but courts have also given a lot of deference to state agencies when they are looking or searching in the context of public health and safety. In this case, again, the state, Cleveland State University, which is a state school, and we'll come back to that, wasn't searching for something specific, wasn't looking for evidence to use against Mr. Ogletree, wasn't looking for a health or safety violation. And here what the court said is, well, you just can't do that with Mr. Ogletree. So it is, and this is after the fact, by the way. So it is a very peculiar situation. Rachel?
Okay, thanks, Mark. So just to kind of give this a little bit more context, we have a ruling from the court that is persuasive, not controlling or binding authority, with a really novel application of the Fourth Amendment. I'm not going to get into that anymore. I'm sure there's plenty of juicy legal arguments that can and will be made on that Fourth Amendment piece. As Mark sort of outlined, it is very unusual. But we want to start now just to kind of dig into the facts, because all cases turn on their facts. And we have a saying in the law that bad facts make bad law. And I think here we have sort of a kind of perfect storm of bad facts. So it's really important that we understand the unique nature of the facts of this case and kind of break those down a little bit further to understand what the court was looking at across several different actors, starting with the school. So Mark, do you want to kind of share what some of the facts were that the court called out with related to the school?
Sure. The court said that the school had a policy, that it didn't really require any of its professors to follow. It was more like the university had a series of recommendations about how professors might choose to use certain security features to make tests more secure. So, for example, students were supposed to have provided photo identification that a proctor could check at the beginning of each exam, but Cleveland State did not enforce that procedure, and quite a few students that take online classes did not have a photograph in the university database. And essentially, it said professors could decide whether a proctor was going to conduct a room scan in the event of each particular test. So that was left to the professor's discretion. And in particular, in this case, the professor had in his course syllabus indicated that room scans would be required. Mr. Ogletree actually objected to that, and the professor then took it out of the course syllabus. And yet the room scan took place anyway on what was extremely short notice, 2 hours prior to the exam. So I don't want to get too far ahead of sort of my assigned section of the facts. Rach, is there anything else you want me to cover? Or do you want me to just turn it back to you?
I think, well, one other thing that I think is critical for this case, right, is that this was a public university. And that becomes critical because of the Fourth Amendment analysis. Do you want to just touch on that just really quickly?
Sure. The Fourth Amendment only applies to government agencies. And that's a point that I made in the article that I wrote in LinkedIn, and it cannot be overstated. So the Fourth Amendment would not apply, does not apply to a private university, and does not apply to any private entities, which is really where most testing organizations fall into the category of private organizations. The Fourth Amendment was, the university was deemed a state actor because this is a state school, and that is, the reason or one reason that the court was able to apply the Fourth Amendment to the actions of Cleveland State here.
Yep. So we're going to keep kind of breaking that down by the facts, and I'm going to turn it over to Don to talk a little bit about the professor and the class.
Yes, as Mark mentioned, in the original syllabus, there was language stating that students could choose to take the tests for the class either at a testing center on campus, which was the typical means, or they could take the test online. And again, as Mark said, Mr. Ogletree did not like that. He expressed his disagreement with that policy, and the professor did change it rather quickly. I think as we see these facts unfolding, it appears that either the professor didn't tell the proctoring company that that was the case, or perhaps he did, but it was not heeded. But anyway, that really leads to some breakdown in how this examination was given. We have to keep in mind that this was during the COVID era, and Cleveland State said that for a student to be able to take the test on campus, that student had to pass a daily health assessment in order to be allowed on campus. Now, Mr. Ogletree would not be able to pass that assessment because he had some health issues that affected his immune system. So he really only had the option of taking exams online. We need to keep that in mind. So because of that, there were certain restrictions on how Ogletree would take the examinations. And remember that this requirement of passing this daily health assessment was established by the college, and all students had to abide by that. They had to pass this health assessment in order to take the examination on campus. If they did not, then they had to arrange for online testing. I'll turn it back to you, Rach.
Yeah. Okay, so by the time it got to test day, you could probably see how school had kind of squishy, maybe these rules apply, maybe they don't. The professor said, hey, you're going to be remotely proctored and have to do a room scan, and the student pushed back, and 3 days later it came out of the syllabus. So you could see where the student had probably a reasonable expectation that he wasn't going to be required to conduct a room scan. Day of his chemistry test arrives, and lo and behold, 2 hours before the exam, he receives an email from a university employee. It was actually university employees proctoring this exam, as far as I can tell from the facts of this case. And the university employee said, hey, we're going to have to do a room scan before you test. And he pushed back and he said, wait a minute, I was told I wouldn't have to do that. I've got sensitive tax information. I have medical information on my desk, and I don't want others to see that. And also, I didn't have notice that you were going to do it. And the employee told him, if I can't do a room scan, then you're not going to be able to test, in short. So the proctoring tool the university used, apparently, was one that worked in a way where when you came on and you were being proctored, not only was the proctor able to see that one student, but they were able to see all students, kind of like we're doing right now with this Zoom. And in the same way, when a student scanned their room, not only could the proctor see it, but every other student online. So when the room scan was conducted, it wasn't just the proctor, but every other student who was waiting online to take that exam could see it. All of those facts become important in the court's holding. And I'm going to go there next just to make sure we're kind of keeping up in time. So let's start with, I'm going to kick it back to you, Mark, on what the court ended up deciding regarding the Fourth Amendment.
Well, the court said that the Fourth Amendment applied, and the court also held that a room scan was a search. And there's probably 10 pages of the court's opinion devoted to supporting those findings and a lot of legal analysis. But essentially, the room scan, as it related to Mr. Ogletree, was declared to be unconstitutional.
So once the court established that the Fourth Amendment applied under the facts of this case, they then applied a balancing act. And Don, I'm going to ask you to describe that just a little bit further.
Yes, absolutely. The court was very quick to say that the university had a legitimate interest in protecting the integrity of its tests. In other words, preventing cheating, preventing information about the test from getting into the public domain or released publicly. And I know a lot of you are familiar with that general issue. So that was a legitimate interest, but that had to be balanced against the interest of the student, of Mr. Ogletree, in terms of his privacy, his right to not have his bedroom scanned, especially when he was only given 2 hours notice of that. And he wasn't able apparently to rearrange these 1099 tax forms. So there was a balance involved in those two sides to this. And one of the things that the court looked at was the fact that there was no notice, only the 2 hours, not reasonable, sufficient notice. Also, the fact that everyone who was taking the exam could see everyone else's room scan, but also the fact that because of the wide variation of choices that each professor had for each course, there was not a consistent application of the room scan policy and procedure. So the court, balancing the interests of the school and the interests of the student, decided that given all of the facts and circumstances, as we like to say in law, the balance of fairness fell in the direction of the student, and therefore the judge ruled that under all of the facts of this case, that this scan was unconstitutional as applied to Mr. Ogletree.
Thanks, Don. I know several organizations, and this is where we'd like to hear from you all again, have made some changes, and we would love to hear from you whether you made any changes in light of this decision or not. So this is the same process, but this is actually a word cloud, so you can use your cell phone again. Just clue into that QR code, click it, and let us know what changes you, or if you're a vendor, perhaps your clients, have made in light of this decision. Because I do know that several have talked about this. So some have stopped using room scans. Some said, we have not made any changes at all. This is wonderful. Some people don't know if there's been any changes. We have a couple of different folks who said they've stopped using room scans or they're going in person. They've had some, I'm assuming that's a vendor who said, a few have asked us to stop doing room scans, but most have made no changes. Others have said, hey, we have consistent rules. We are offering individual rooms on campus if people need that. We're giving notification. So this is fantastic. Thank you, everyone, for participating this way. I know it's hard when you're doing these things remote to be able to get this information. So as you all continue to do that, one of the questions that that was raised was why the court didn't treat this as a breach of contract case. And the court can only treat the complaint that is in front of it. So I'm going to assume, I didn't see the complaint, but I'm going to assume that was never a complaint that was raised to the court to decide. This does seem like it's a case that was ripe for making exactly the claim that the student and their attorney made, which was one about privacy. So that's why I just don't think that the contract claim was raised. So we have several folks who have said they didn't make any changes at all. Some said we've stopped using room scans. And so we're going to break this down a little bit more and share with you what we see as some of the key takeaways from this decision. So let me start just by pointing out the fact that, and Mark, you had mentioned this, one of the concerns of this court was that the school wasn't consistent in how they handled their own policies. So let's talk about that as a key takeaway.
Right. The court is basically finding, and this is not unique to any type of analysis of government action under, constitutional authority. The court doesn't like the exercise of discretion by individuals. If you are a state actor in particular, although I think there's value in this for all testing organizations, even if you're not a state actor, the court wants to see clearly defined policies that are followed consistently. So discretion, in other words, a professor having discretion to choose to enforce some rules and not others, enforce some rules on some days and not on others. Discretion is a bad word. Professors should not be able to do whatever they want, whenever they want. So the takeaway there is, we say be consistent and follow policies. Number one, have a policy, okay? And frankly, the more complex you make your policy, in my experience, the harder it will be for your constituents to follow. So one of the things that I have suggested as a possibility, and I don't mean to, suggest that this is an easy thing to figure out, but if you could sort tests at a university, for example, into low stakes and high stakes, and that could be the subject of another 2-hour discussion. But let's assume for the sake of this discussion that you could sort tests at a university into low stakes and high stakes. You may have one set of rules that applies to low stakes testing and another set of rules that applies to high stakes testing. But whatever those rules are, they don't change. And they have to be enforced precisely as they are. And, we're going to get further along in this so you can see where the court ultimately came out on the whole room scan issue. If there's something inherently bad about room scans, a little preview, there isn't, okay? But, you could decide whether a room scan really serves your interests. And you could decide not to use a room scan. But I just want to be clear, we're talking about room scans, but the concern about having a policy really applies to your entire test administration process. So we're not just talking about room scans. So Rach, passing it back to you.
Yeah, I think so. If you're going to have a rule, you want to make sure that you are consistent in applying the rule and that you follow it yourself. And as Mark said, we all have policies when it comes to administering our exams. Maybe it's about the identification you need to bring. But you want to be consistent, not just for privacy purposes, which is what the room scan was looking at. There's all sorts of issues if, I let one person in and they don't have an ID, or I let one person get away with not doing a room scan, but enforce it against another. Courts don't like that kind of picking and choosing without clear exceptions. And having that discretion, as Mark, you said, can be really, really troublesome down the road. So know what policies you want to have, and then make sure that the folks applying those are enforcing those accurately. Another issue that the court brought up was the not just the inconsistency, but the lack of notice here. Don, do you want to talk about the notice question?
Yes, there is notice and there is adequate or sufficient notice. Obviously, when a student is given 2 hours before an exam to prepare for the room scan and the examination itself, that would not be seen in just about any context as reasonable or adequate notice. Once again, the court really seized upon that as an argument that supported Mr. Ogletree's position that his rights under the Fourth Amendment were violated. Also, to go back to this consistency aspect, I want to emphasize to you just how much discretion the professors were given. It really was unfettered discretion. Professors could give examinations that were open book. They could give examinations that were strictly proctored. They could give examinations that were totally unproctored. So the court reasoned that if the room scan is such an important aspect of making sure the examinations are good, then why do you allow professors to even do away with any aspect of that? That really argued against the university's position that they needed to do the room scan in order to protect their examinations and to prevent cheating. So when we're looking at all the facts of this case, they're putting it all together, the lack of adequate notice, the fact that other students could see the environment of other test takers, but especially the fact that the university gave professors unfettered discretion, I would say, in terms of how they gave their examinations and the stringency of the requirements. All of those facts really argued against Cleveland State University and contributed to the court deciding in favor of Mr. Ogletree.
Yeah, that's a really great point. It's a balancing factor, right? And the court said, well, yeah, you've got this legitimate interest, but then it's like the more they kind of kept stacking up what was happening factually across the, broader university in that class for that student, it just didn't end up weighing in the school's favor. One of the other key takeaways is not only be consistent and give notice, but you can get express consent from someone. You can waive a constitutional right. And you can get express consent from someone to go ahead and scan their room. So when someone is signing up to say, hey, I want to take your course, and you're saying, well, it's going to be online proctored, or to take your exam, and you're saying it's going to be online proctored, and in doing so, you're going to consent to a room scan, then that makes a big difference in terms of how this case would have turned out, for example. So giving not just notice, but also getting some express consent from a test taker could have, I think, tipped the scales. Does that make sense to you, Mark?
A little slow on the unmute, but yes, that makes perfect sense. And waiver is a really longstanding concept when it comes to many constitutional rights, but I mean, in particular, when it comes to the Fourth Amendment. One of the most successful ways that law enforcement officers, ensure that they're not violating the Fourth Amendment is to obtain consent from the person whose property they want to search or person they want to search before they do it. It certainly does make sense. And here, again, we're not talking about criminal matters. It seems fairly straightforward that a university could obtain an explicit written consent up front that would kind of knock out any of these Fourth Amendment issues when it comes to remote proctored online tests at the school.
So I think one of the things, though, in light of this case, we certainly have seen a lot of attention from the media. We've had some test takers who have brought this up in the context of testing. And so one of the things that we wanted to encourage, in addition to these key takeaways on, consistency, following your policy, providing notice, getting consent, is also to say, let's be proactive and also think about some of the other considerations the court talked about here. And one of those is proactive preparation for an alternative arrangement. Don, do you want to speak to that a little bit?
Yes, I'm happy to, but if I may, first, I do want to address two things. First of all, Alan Thiemann, a very respected colleague of mine, wrote in the chat that there's no contract between a student and a professor. Indeed, there is no contract between the proctoring entity and the student. The contract is with the institution. I agree with Alan on that. And there were some other comments I don't think we want to address at this point. But other point I wanted to raise is the fact that the room scan was very limited. It was not able to make sure that the test taker couldn't go to another room and look up answers or whatever. So the court also said that it doesn't seem to be a strong interest of the school to emphasize this room scan when there were so many other ways of circumventing the prevention of cheating. And that's something that the court did talk about at great length, which also contributed to the decision. But to answer your question, Rach, yes, now this is not a ADA case. However, there are principles in that area of the law that I think apply in this situation. The ADA states that test takers must provide the tests in a place and manner accessible to people with disabilities, or offer alternative accessible arrangements. I like those 3 A's. That's how I remember that, alternative accessible arrangements. So they could have made an effort, Cleveland State, to accommodate students in the situation of Aaron Ogletree by providing these reasonable alternatives, which would still protect the integrity of the test and prevent cheating, etc., but would be sensitive to the fact that those who have immunocompromised situations, which was the case with Mr. Ogletree, there should be a sensitivity to alternatives that might be better options for these types of students other than taking an examination in the student's home, in the bedroom, and again, only giving the student 2 hours to prepare for that. So these alternative accessible arrangements are important. And I will turn it back to Mark at this point.
Well, I'm trying to see where I'm supposed to be going at this
I
point.
got you, Mark. So one of the
Thanks,
other
Rach.
things, yeah, that's okay. So as a testing program, you may want to think about, you may have some individuals who push back and say, I don't want to test in my home. I don't want to test online. You may want to think about then, to Don's point, what alternative accessible arrangements could you provide for them? So could they test at a library?
Right.
Could they test at a testing center? One of the other things that kind of happened here was, I don't know that Cleveland State really understood how that testing process worked. But as testing programs, you should absolutely understand what process your vendors are using to conduct online proctoring and who's going to see those videos. And Mark, I think you were going to talk a little bit about that because it's important for you as a testing program to know, well, what are your proctors doing and what are, who is has access to that?
Right. Yeah, I mean, the court certainly identified the fact that others who were taking the test could see each other's room scans conducted by the proctor at the time of the room scan. So that sort of opens up that room scan to be a greater invasion of privacy and, frankly, is easily avoided. So that would be another important takeaway from this case. Yeah.
Understand the process that whether you're having it done at a university test center, whether you have a vendor that's doing it, whether you're doing it through your own staff, you want to understand what that process is like.
Now, just one counterpoint to that. I mean, I understand that the court was bothered by that, but the court was bothered by a lot.
They were.
If you go to a test center, everyone who's testing can, see the faces of the other people who are testing. I think that the one point that I want to make here, though, is the difference, because it's easy to get cynical about this opinion. The difference is that people who are testing at home,
exactly.
have a greater, expectation of privacy in their home than a person who goes to a test center where they expect to see other people. So
because it's public,
to make that
right?
point.
Yeah,
right.
You're already in public, right? So you have a much different expectation of privacy and what people are going to see on you or about you if you are standing in the public street versus if you're sitting in your bedroom. Makes sense to me. What I think the university wasn't probably as aware of was how many people were actually seeing that room scan beyond the proctor. So just know that. I think that's a good takeaway. A couple of other good takeaways. Plan for pushback from folks. So you want to make sure that your proctors understand what you want someone to do. If they do say, I don't want to do a room scan. In this instance, I don't know that the proctor was adequately informed, first of all, that a room scan wasn't required by this professor. And secondly, what the proctor should have told the student, right? Which could have been something along the lines of, I'll just make a note of that and let your professor know that you have those concerns and they'll work with you on another arrangement. You want to be able to give your proctoring staff some kind of language along those lines so they know how you want to, as a testing program, respond if someone pushes back like that. And also, I would say, you know, one of the things that the court talked about a lot was there's no evidence that these room scans are necessary or that they're even effective. And so I did want to just spend just a little bit of time talking about that. I worked with examining proctors for a period of time in the fall of 2022 to determine the effectiveness of room and desk scans. I'm also incredibly delighted to share with you an image that I generated on OpenAI's DALL-E system about what does that look like when someone is testing from home and maybe has some unauthorized materials available. And so I wanted to just give you guys a little preview of what it was that we found. And start, I guess, asking you all a question. So what do you think we found the most of when we were doing this? What were the most common concerns that were identified by proctors, examining proctors during room scans? Was it unauthorized digital devices, unauthorized books and materials, or was it additional people in the testing room? So again, when we think about this case, the court was saying, yeah, the university has a legitimate interest in coming up with fair procedures and knowing that the scores of their exams are valid, right? I mean, that's kind of, they're in the business of providing knowledge and education and then, you know, measuring that for a grade and a degree. So they said you have a legitimate interest in knowing how people are testing, but the way that they were applying it there, they said, we don't really have any evidence that those room scans are even helpful. So we've got about a third of folks in now. 53% said the most common concerns identified during a room scan were unauthorized digital devices, 28% said unauthorized books and materials, and 20% said additional people. Again, images generated by DALL-E, I'll give you what the outcome was. In 342 instances, they did identify, proctors identified before the exam or used desk scan and room scans to confirm that the individual was not alone in the testing area. And so they used those to confirm that it was quiet and they were alone and they had no other distractions in there for either starting or continuing an exam. In over 4,000 incidents, they identified unauthorized books, unauthorized notes, and other materials that were in the testing environment that they asked the testing for them to remove from the testing environment before they started the exam. They found almost 4,900 unauthorized digital devices. That could be anything ranging from a second computer to a second monitor, cell phones, smartwatches, tablets, in that testing area that they asked test takers to clear out before the exam could begin. So I think that certainly supports the value of online proctoring and the room scans that are conducted by proctors before an exam begins. And I think it's interesting to consider as you're looking at that balance of interest that we discussed earlier, it'd be interesting to think how having this type of evidence might have impacted that court's decision in that case. One of the things to make you all aware of, I told you this is sort of a continuing saga and it's not the end of the story. The court in the initial order said, hey, parties, go back and confer on the next steps for a remedy. They conferred, not surprisingly, they couldn't agree. So they filed some additional motions, and I'm going to ask Mark to say what the amended order ended up providing, which I think is incredibly instructive.
Just one additional comment, because I don't think, you know, you can really state this. This really needs to be emphasized. On your last point about the absence of data supporting the use of room scans, the court wrote in its opinion, besides pointing to the potential deterrent effect, defendant does not offer much argument or evidence to support the efficacy of room scans. Perhaps experience with room scans is too recent or not extensive enough to offer much in this regard. Whatever the case, a record of sporadic and discretionary use of room scans does not permit a finding that room scans are truly and uniquely effective at preserving test integrity. So I just, you know, I don't want to, I think it's really important that if you use these tools, you have data to support them. Let me just say that. And if these data that Rach just mentioned were submitted as evidence in this case, I don't know if we'd have this decision. So, but coming to the question that you asked about the amended opinion and order, the original opinion and order was issued in August. And then in December, after a lot of back and forth and motion practice, the court issued an amended order and a permanent injunction. And an injunction is just another word for an order telling a party that either they have to stop doing something or they need to do something. And basically what the court said is the court permanently enjoins, which means orders them to stop, Cleveland State in connection with any exam, test, or other assessment from subjecting Mr. Ogletree to a room scan that is administered without offering a reasonable alternative or without his express consent. So there's the keys to the kingdom right there. You have to either get express consent in advance. Yes, it must be voluntary and informed, or you need to offer a reasonable alternative. And so it's also important to point out that the plaintiff tried to get this turned into a class remedy to apply to all Cleveland State University students and frankly to all students everywhere. And the court, you know, with some extensive analysis said, no, the facts here don't support that. So this is a very narrow holding. It only applies to Mr. Ogletree. It doesn't even apply to any other student at Cleveland State, but there's still a lot of important things to learn from it.
And the court did make a lot of comments, like not that other states could, or not that other students couldn't follow in Mr. Ogletree's footsteps, basically. So, you know, sort of hinting like others might try this, but I'm not going to give a broader remedy here. And then Don, this is actually on appeal, right? So the saga continues.
Yes, indeed. And at the appellate level, the court does not relitigate the facts, but rather looks at the legal issues to see whether there was any error in how the trial court looked at in this case, the Fourth Amendment. So there will be attempts, I'm sure, to argue by state's attorneys that this was a wrong application of the Fourth Amendment. And as Mark mentioned, a lot of the opinion focuses on that. And just the legal issues will be reviewed and we will see what happens with this. Rachel?
Yeah. So we asked you all at the beginning, hey, what do you think the court held in this case? Well, it wasn't all of the above. It wasn't that room scans are illegal and shouldn't be used for remote proctored exams. It wasn't even that room scans can't be used in universities. It really is a very, very narrow holding that room scans are unconstitutional as to Mr. Ogletree under the unique facts of that case. So there are still really good learnings that we can take from that. But I do think that there's been a lot of misinformation out there, and hopefully this helps to, you know, kind of allow people to balance the ruling a little bit and understand how really narrow of applicability that ruling has across our industry. So with that, I know we're at the top of the hour. So on behalf of Don and Mark, I want to say thank you for having us here, CNG Group. We all obviously feel pretty passionate about this case and would be happy to talk with folks further if you have questions. And I know Kate's going to say, don't forget to fill out your survey.
That is actually very accurate. I've already put the survey in the chat if you want to do it now, but we'll also send it out to you. But thank you, presenters. You guys did a great job today. It was really interesting. And everyone, our next Chicago CNG meeting will be May 17th in Chicago. We'll be sending out some more information for you guys about that. But thank you, everyone.
Thanks, everybody.
Thank you.
Thank you. Goodbye.
Thanks, Rachel.
Thanks, Kate. Bye.
Bye.
Thanks, Rachel. Thanks, Mark. Thanks, Don. It was great to hear from all you guys. You guys really.
Bye-bye. Thank you. Thank you.
Thanks,
Bye-bye.
Don and Rach, and thanks, Piana.
Thanks, Mark.
Pull this all together.
Yeah.
Yes.
Thank you, everybody.
All right.
Okay,
Speak to you all
take care.
later. Bye.
Bye-bye.
Bye.
Thank you.